Hi, I'm Matt Welch for Reason TV. I am at Freedom Fest in Las Vegas with one of the most Freedom Fest-tastic lawyers in America. I just did that. Randy Barnett, thank you so much for joining us. Randy Barnett is affiliated with Georgetown University. He is widely credited with being with sort of the intellectual brains behind the challenge to Obamacare a couple of years back. You just wrote a piece this morning in the Wall Street Journal, I've just been told by a reliable source, having to do with NSA surveillance and whatnot. What's the upshot of all that?
Yeah, I mean, the issue is whether it's constitutional for the federal government to seize vast quantities, blanket quantities of private data from private companies. We're normally accustomed to thinking of search and seizure, so first you get a warrant to search, then you seize what you find. But what we have here is blanket seizure before we do any searches. And so first the government seizes all of these databases, and then by using data mining they then get probable cause for their later search. But the question is whether a blanket search, just like general warrants used to be at the revolutionary times, whether a blanket search is constitutional or not. So that's one of the big problems that we need to think very hard about. The other major problem is simply the secrecy of the programs. We have supposed to have a Republican form of government, and that means that the people ultimately are the check on governmental power, but the people can't check governmental power if they don't know what the government's up to. Even if some special intelligence committee knows what's up, the people don't know what's up, and we didn't know it was up until these illegal leaks happened, and that's how we found out. So there is a real fundamental challenge to having popular sovereignty if the people can't know that the government is collecting data on them, and by confiscating it from private companies.
Hasn't the court system up to the Supreme Court been ratifying these kind of fake oversight, or oversight by one judge over here in this room who can't really know what's going on from the executive branch?
Well, in this case it's even worse, which is the other part of the piece I had this morning, and that is we have a secret court, the Foreign Intelligence Surveillance Court, who was put in place basically to authorize secret search warrants, which is not all that unusual because judges usually authorize warrants what they say ex parte, that is, it's not adversarial. The police go, they get a warrant signed. When I was a prosecutor, I used to get warrants signed by judges ex parte. But instead of just doing that, what they're doing is they're having constitutional rulings on the constitutionality of this data seizure program in secret, without the companies that are actually having their data seized be represented. It's not adversarial, and the opinions that they've written to justify it, they're also secret. So we don't even know on what basis these have been upheld.
They're interpreting the constitutionality in secret?
Yes. Yes, we just found this out. Maybe other people knew about it, but I just found it out, and then I wrote this piece because it seems like it violates the due process of law. So we have one problem, Fourth Amendment, which is an unreasonable seizure of mass quantities of data from private companies that you do business with on a contractual basis. And the other one is secret courts passing upon the constitutionality of the program, not individual searches, but the whole program, in secret opinions, and that's a violation. I think that's a serious due process clause problem. It's not the due process of law to have non-adversarial secret proceedings upholding these programs.
How do you unpack that? It feels like there's been, since basically the modern national security exception was created in the late 1940s after World War II, based on this Air Force case or an airplane case of some sort, there has been consistent deference to the executive branch on issues of national security and secrecy.
There's no question, and in fact, I haven't really thought about legal challenges that might actually work. But the first thing we have to do is make up our mind whether these things are appropriate or not, just so we think we know whether they're appropriate or not. Because in wartime, signals intelligence is something the government does engage in, and so the fact that the government's trying to ferret out communications from terrorists is something that would be associated with a wartime exercise. So it's not automatically bad, but I think I've reached the conclusion that blanket seizures of data of all Americans, of their telephone usage and their internet usage, this is very much like general warrants. First you search and then you find evidence of guilt, which is what general warrants did at the revolutionary times. It's the reason why we have a specific warrant requirement. But that's for searching, and we also have to worry about the seizure part.
Other libertarian legal theorist, Richard Epstein, most notably, has been making a different argument about the NSA, saying basically there are internal mechanisms of oversight, and also this is national security. This is what we do. We should be doing this. What's your response?
Well, first of all, I don't deny the fact that surveillance can be done in secret and actual searches can be done in secret. But the existence of an entire program like this is something that, if it's kept secret, the public simply cannot provide the check that Republican governance is supposed to provide. In a Republican system, ultimately the people are sovereign, and they're the ones that have to make the ultimate decision, and if they don't know about this, they can't decide. So I know Richard disagrees with me. I got a friendly email from him this morning about my piece, expressing disappointment that I came out with that conclusion, but saying that he himself was concerned about what he's learned about the secret courts passing upon the constitutionality of it, and that he plans to say something about it pretty soon. Online. So I had two major arguments in this piece, and I think I might have gotten him on one of them.
The Supreme Court term just ended. I believe I remember hearing you saying that at least on some of the issues we're seeing an interesting strain of libertarianism emerging on the court, and if I misattributed that to you, I apologize in advance. What struck you as particularly interesting in this last flurry of decisions?
Well, the Windsor case that I had an amicus brief in took an interesting tack. Who knows whether that'll mean anything for any future cases? You never know about that. But it took this. Justice Kennedy wrote the majority opinion. He has a very strong interest in liberty as a value. I'm not saying he's a libertarian, but he's a kind of his own libertarian. And so, but liberty is at the core of what he's thinking about. And he basically made a move that no one's seen before, and that is, he said, because when states have recognized the liberty to marry, then it's incumbent upon the federal government, there's a presumption that the federal government essentially should respect that liberty and should give heightened scrutiny to laws like the DOMA, the Defense of Marriage Act, which infringed upon that liberty or restricted or made it costly to exercise that liberty. So he combined state protection of liberty by the states with heightened scrutiny of federal laws. It's not something we've ever seen before. It's not the way it's supposed to work.
So it's because states have expressed this value, and therefore the federal government should think about laws that conflict with those values.
Absolutely. That's exactly the logic of the opinion. As I say, I don't know if that logic will ever be applied in another case. You never know. But it's if it was applied in another case, it would basically give states the opportunity to protect liberties and then let the courts scrutinize the genuine necessity and reasonableness of federal laws that interfere with that liberty. Anyway, it was an interesting opinion. It's like Bill Murray says in Groundhog's Day, it's different. And at the end of the movie he says, anything different is good, but I'm not sure anything different is good, but in this case, it's kind of a liberty difference.
Like reverse incorporation? Am I thinking about this through correctly?
It's basically it's sort of how you recognize a fundamental liberty. I mean, he's not using the traditional framework. He's not using the standard framework. But it's not clear how serious this doctrine is, whether this is a doctrine that's only going to be used for this case, because this result avoided the court having to strike down or say that same-sex marriage was constitutionally required throughout 50 states, and there were not 5 votes for that. So they basically wanted a way in which they could, in a sense, uphold gay marriage where it's currently recognized and not impose it on states where it wasn't. Well, this gave him an opportunity to do that, and so I don't know if he'll use it again, but it's a move we haven't seen before, and if it were used again, it's got a libertarianish quality to it.
The Roberts Court in particular has gotten pretty decently high marks on protecting speech. Anything in this most recent flurry of cases that you see as a further?
I don't know that we had, I'm trying to think now, I just did my supplement. Did I put any speech cases, freedom of speech cases in my supplement? Now I can't remember. Maybe I did. I'm in Vegas, man, so it's like, you don't expect me to think such serious thoughts. But I mean, obviously, they are very skeptical about regulation of political speech, which they should be. I mean, this was a huge mistake that the Supreme Court made by allowing Congress to regulate the speech by which people get elected to Congress and by which people get elected to the president. And they've been doing it for years and years and years. And this court, there's 5 justices who are skeptical of this. They keep cutting it back and undermining it in this gradual way that they seem to like to do, and that's a movement in the positive direction. And since I think they do so many things I disagree with, I certainly want to commend them when they do something that I think is good.
That's great. Randy Barnett, thank you so much for joining us.
It's a pleasure to be here at Reason.
And for Reason TV, I am Matt Welch.